Welcome to the I Got Fired podcast for people who've been fired or afraid that they might be. My name is Tom Spiegel. I'm the host of the podcast. And before we get started today, just a little bit of legalese. This is not intended to be legal advice. If you want legal advice for your case, then yes, you should go consult or hire a lawyer. Today, I am thrilled to be joined by someone I have known for many, many years. We won't talk about how many years, but many years. I have known Margeaux Thomas, who was a fantastic lawyer who worked at a big DC firm, or no, Virginia firm, William Mullins, right before you opened your own office in 2016, which now has a number of employees. And Margeaux has worked for entrepreneurs, small business owners, and everything from complex commercial and real estate litigation to class action lawsuits at the trial and appellate level in Virginia, Maryland, and Washington, D.C. I'm not even going to try to go through her very, very long list of accomplishments here. I would suggest that you go to her website, thomaslawplc.com. And you can see her very impressive bio there. So today we are going to be talking about everything mediation related, and Margeaux has done a lot of mediation and has written a lot about it and talked a lot about it. I know it is a subject near and dear to your heart. So we're gonna do that. It's a great topic. It's really where a lot of cases end up being resolved. So this is obviously for people who don't do a lot of mediation, maybe have never been through mediation. So let's start, Margeaux, with what is it? What is mediation and how does it work?
Well, first, let me say thank you for having me, Tom. I'm really excited to talk to you. I love mediation is my jam. I really love it. So I'm happy to be talking about something so near and dear to my heart. I am a huge proponent of mediation, and basically it's a voluntary process where parties come together with a neutral third party and try to reach a resolution, whatever the dispute may be. So it's usually more productive if people are there in good faith and really believe in the process. But, we can talk a little bit today about mandatory mediation and voluntary mediation, but either way, it is voluntary. So the parties really have to be, wedded to the process and want to be there and dig into it for it to be effective.
Yeah. So I think I know why, but I want you to tell people who are listening. So why are you a big fan of it? What is it? Why is it so important to you in particular?
I think that just as far as resolutions go, when parties can be part of the process of creating the resolution, I think it tends to be more effective and people can they can accept it easier. It's easier for them to move on with whatever that resolution is. There's like some buy-in that they have versus going to court where somebody comes up with a resolution and forces it on you. And, that can be favorable or very unfavorable. But I think that across the board, when it's something that the parties agree to voluntarily, it tends to be more productive. So it can save a lot of money. It can save a lot of time. It can save a lot of emotional energy. And there's a lot of different ways to do it. There's a lot of different times when it can be effective. It's just not like a one size fits all thing. Mediation can be done in a lot of different ways, and it can be tailored to meet whatever the demands are of the litigation. And I like it because it's flexible and it allows the parties to reach a resolution that they really can live with and have some buy-in.
Yeah, that's absolutely right. It's the only place really you get to choose, right, as the client, what the resolution is to a certain degree, because otherwise you're either going to lose or a court or jury is going to decide what the resolution is, which may not be as favorable to you as something you could craft on your own, again, in a settlement with the other side. So for someone who has never been through the process, kind of paint a picture for me. What happens? You walk in that morning and kind of paint by numbers. What happens in a mediation?
So I tell people a lot. There's a lot that happens before the mediation.
We'll get to that in a minute.
There's a lot of preparation that goes into that.
Yeah.
But on the day of, you basically walk in and there's usually an introductory session with the mediator, and the other side is there. The attorneys are there. Everybody's sitting at a table, and the mediator kind of goes over the ground rules, just stating that basically everything is confidential. It can't be used outside of this venue to, in the litigation, that they're a neutral, that they're not particularly advocating on one side or the other, but they can evaluate the merits of one side's position or the other, and they can share that information when asked or when they deem it necessary. That they are basically going to go between both rooms and get both sides of the story and try to help the parties facilitate a resolution. So they start there, and then there's an option of whether the attorneys for the parties will give an opening statement, and that is usually something I am not a big fan of because it kind of gets the people thinking an adversarial process and sitting there hearing the other lawyer's opening statement of what would be at trial usually puts people in a just not the best headspace, and it takes a long time to kind of get them back to the let's try to reach a resolution. It puts them more in like a fighting posture, which I don't think is like the most productive thing. But sometimes they have opening statements. Sometimes those are very extensive. Sometimes they have demonstrative. Just kind of depends on what the parties have agreed to in advance. And then normally the parties will go in separate rooms with their attorneys, and the mediator will go back and forth between the rooms. And sometimes the mediator will have a caucus with just the attorneys. And the mediator will get a starting number, and there may be some ancillary issues as well that don't have to do with money, but the mediator will convey that information to the other side and talk to the other side about the strengths and weaknesses and where they should be and what they think the case should settle at. Sometimes they insert that information and they just go back and forth between the two rooms with the parties and try to broker a deal.
Exactly. Yeah. So, and you talked about kind of the preparation that you do beforehand. What do you do with your clients? What do you recommend that folks do before they even walk in?
So I have a competitive nature and have a very long sports background, and I'm now kind of doing that with my kids going forward. But so I consider it just like basketball. Like, the game is really won or lost before you step on the court. It's decided in your preparation for the game. Like, if you are showing up to practice and putting in the hours and learning the skills and going over the plays and you're looking at the other team and evaluating their strengths and weaknesses, then, the game is just, the outcome of what you have already done. And I view mediation the same way. There are some people who walk into mediation, they're like, oh, we'll just see what happens. And, that I feel like is not a productive approach. We spent a lot of time before the mediation going over where it is going to be at, who the mediator is, what way the mediator tends to lean in a particular case. I mean, a lot goes into selecting the right mediator who has the background to help these particular parties in this resolution. There are some situations where a mediator is just randomly selected, but if we have any choice in where the mediation is going to be or who the mediation is going to be with, then a lot of time goes into determining those factors. And then a lot of time goes into meeting with the client and going over what is, the best case scenario if we don't reach a mediation and what is the worst case scenario if we don't reach a mediation, because that has got to be our, this is where we're trying to be and this is where we're going to walk away. Like, you need to know what's your, this is poker table, what are you betting on? Like, what are the scenarios here and what is the percentages dealing with those scenarios? Because if you go in there without really understanding what you want and how to get there, it is very unlikely that you're going to reach the resolution that's the most beneficial in that scenario. So we meet with the clients and we have very difficult conversations about where we see this case going, what it will cost going forward, what they were likely to recoup, and then we try to come up with a number that weighs all of those different variables and that is our client can accept or is willing to take. And the mediation is usually just it's like the performance of that. We've already discussed it. We know where we need to get. Now there's another part where you write a mediation statement for the mediator. And a lot of time is spent with that as well, because when we walk into the mediation, we want the mediator to ideally say, look, liability is not an issue. The only thing we want to talk about now is a dollar figure. That's how we know that we have done our job, because we've already convinced the mediator that our position is strong. And normally we're trying to get the other side to write us a check of some sort. I do a lot of business disputes, so there's a lot of buyout discussions. and we get the mediator to, let's not talk about right or wrong. Let's talk about, a dollar amount. And that is because we spent so much time on the front end painting the picture of who our client is, what they want, why they deserve it, what the legal issues are that support whatever the resolution is. So I can say hours are spent beforehand preparing for it and making our client feel as comfortable as possible, understanding the environment that they are going to walk into, because that's important as well. You want you don't want this to be a complete surprise, and you're anxious. It is going to be an anxious process, but the more familiar and prepared you are for that situation, I think the better the outcome.
No, absolutely. Can you, one thing you mentioned this, and particularly for employment law, that I like to do, obviously the number is the big one, right? What are we willing to, as you say, what's our range? What we'd be really happy with, at what point are we walking out of the room? But also for our clients, like really going over the non-monetaries, which sometimes like people, I certainly have, you kind of in the heat of battle, everybody's trying to get to the number. It's late at night. Sometimes there's been a lot of back and forth, and you agree to a number, and everybody kind of walks away, and then you get the agreement. Often with employment law, it's often drafted, at least in the first instance, by the employer, and there's gnarly non-competes. There's a really lopsided non-disclosure, and so I have, for myself, had to kind of learn over the years that you got to nail those down too, because there's nothing's worse than getting to a number that everybody agrees on, and then having my client look at the agreement, or even me look at the agreement, like, there's no way we can sign this. It's got all these restrictive provisions that really should impact the dollar amount if they want all these restrictive provisions. Do you have any thoughts on that?
Yeah, I think that those ancillary issues or non-monetary terms can play a very important part. And, having that discussion before you go into the room about whether this is going to be confidential, whether there's going to be a non-disparagement clause, whether there's a laundry list of terms or things that people may deem very important that, to the outside may not be that relevant. But I mean, if that is the client, and, money sometimes is not the most motivating factor to some people. There may be some property that they want back, or, some other, I've just had lots of crazy scenarios where, there's lots of things that people care about that they need in addition to the monetary number. I've had a case where they wanted an apology. I mean, that was a huge part of it. And that is something that is rarely ever given in these
Absolutely.
scenarios. People never admit guilt. They just say, here's a check, normally. I mean, that's what happens. They don't say, I'm sorry, and we shouldn't have done this. But if that is what your client wants, then that's something you need to determine very early on whether, we can, if that's even on the table. So, yes, I think it's very important to focus on those. And one way that I have found to be effective in that, and a lot of mediators are starting to incorporate, is drafting an agreement before the mediation and sending that to the mediator. And there are only certain things that are usually changing, the money and a couple of non-monetary things, and getting all of the rest of the things that are in every agreement agreed to in advance, such as, venue or attorney's fees, or, mutual releases or things like that. Like, if we can agree to all of those things that are not really an issue, and then go into the mediation and focus on a few key terms and just plug those into the agreement, it makes it a lot easier.
No, I think that's a great idea, because I think even for the other side too, right? Because
Mhm.
if we can all agree, like at least in broad terms, what the final agreement's going to look like, then just you're right. And if it's just okay, we just got to fill in these not important blanks, but we've just got to fill in these blanks. And if we can do that, then everybody's already agreed that the rest of the language looks okay. So I think that can solve some problems on both sides. Can you talk a little bit? You mentioned, and I know this depends on where the mediation is occurring, and we can talk about the different venues as well. But like you mentioned, selecting a mediator. Talk to us a little bit about that, because I'm sure some people are like, "Oh, you get to choose who the mediator is." How's that process work?
So, in Northern Virginia, where I primarily practice, there is a group of retired judges that mediate cases, and a lot of the mediations, people pick that group to do mediations because they've got maybe 100 or so different judges. And then you can look at the resumes of the different judges and what courts they've been in, what type of, primarily cases that they've handled, what their background is in. And you can make a decision, based upon that information about who might be the most favorable. And although they're a neutral, they are usually effective mediators going to, take, they are going to consider the liability and say, I think this person probably has a much better case, right? So if that person tends to handle consumer cases or they have like a public defender background, that comes into play. Or, were they in the patent world and dealt with all IP issues, or, do they come from a business law background? All of those things. And, judges make certain decisions, and there are a lot of bias that can come into being a judge that they don't even realize that they can lean a certain way. So, we try to just do our due diligence. If I haven't been before the judge before, I certainly reach out to the community and ask people their experience. And another important factor, I think, is, there are attorneys that are mediators, there are judges that are mediators, there are people who aren't attorneys who are mediators. I mean, there's no like universal qualification to be a mediator. But I do think it is a specific skill. And just because you're a very good attorney does not mean that you're a very good mediator. Just because you're a very good judge does not mean you're a very good mediator. So the due diligence goes into talking to people who have used that person in the capacity as a mediator. I think that is very important. There are a lot of judges that are just getting off the bench and transitioning into mediation, and we want to see how they adapt to mediation, because it is a different role. In the judge role, they are usually making a decision if it is a bench trial. That is very different than trying to get the parties to facilitate their own resolution. And judges may or may not do a lot of that while they're on the bench. So, part of the due diligence is determining, how effective they have been as a mediator. What is their percentage of cases that they have settled through mediation? Are their percentages very high? And there's a few judges that are extremely sought after, that have very high rates and very high success percentages. And that is just not by chance or coincidence. They're very good at identifying issues and helping people overcome that impasse and reach a resolution. So those are the things we're trying to evaluate on the.
Yeah, absolutely. And I find once you mentioned that judges, who are really good at it, that I find they're kind of the sweet spot of course, being able to get people to a negotiated settlement, but sharing just enough of their thoughts on liability or what the issues may be. If you get a really good judge, sometimes, as you mentioned, you may have appeared before, like they know the cases, they've seen, tried, a dozen or more cases, just like yours. And to have that judge be able to say, hey, particularly if you're at a sticking point on either side, with the money, maybe a defendant's coming in really low, or you've got a plaintiff who's really, really high, and the judge saying, hey, look, this is of course your mediation, but I've tried a bunch of these cases and I don't think you're going to get to that number. Of course they're not deciding the issue, but just for them to share enough of their, I find it very valuable sometimes. And I think particularly for the client too, who, I think for the most part, they trust their attorney and they trust the process to be able to, but to hear somebody that used to wear the robe say, hey, I understand, but I've never had a case come in with that kind of number, either low or high. That gets people to, I think really kind of pay attention and move the needle sometimes. So absolutely.
Yeah, I think they have to say it in the right way.
Oh, yes.
Because, they could kind of be too aggressive with that and, turn that party off and say, well, they don't really know. They're not going to be the judge, and that's not helpful. I mean, they have got to, there's like two hats, the evaluator and the facilitator. They've got to wear those different hats at the right time and still make the person they're saying, look, your case is worth half of what you think. They've got to say that in a way that person still feels heard and acknowledged and understood. And I think that's the hard part. They just can't be a judge and say, look, you lost. That's all they have to do as a judge. They don't have to explain it to you, get you to buy in. They just say, look, you lost. That's it. So I think that there's a lot more nuances to it when trying to get somebody else to buy into the reason why their case is not worth what they think. And sometimes the attorney is not helpful. They're telling them their case is worth way more, which makes it even more difficult for a judge to come in and say, your attorney's great. but listen, your case is not worth that much, you know?
Yeah, yeah, absolutely agree. I think you're right. They've got to have already, got the client's trust. They can't come in out of the gate. It's usually, you're right, because the good mediator is worth his or her weight in gold because they know that little window, right? Like where they're like, okay, they're listening to me now. We've been at this for 4 hours, and again, not coming in heavy handed and saying you win or you lose, but just saying, hey, I'm just going to share my perspective on where you are. And you mentioned another good point, which sometimes happens in mediation, is knowing a good judge, good mediator, knowing when to pull the attorneys out and say, hey, let me talk to you guys separately, and pull you out of the room and kind of lower the volume or kind of reach some kind of kind of get things back on track. That I've seen also be another effective tactic, but you've got to have enough experience as a mediator to know when to do that. So talk to me about different venues, like where does mediation occur, and how does that affect how mediation happens?
Great question, because the landscape is changing. With COVID, a lot of mediation started going virtual, and that was the newest. Most mediations prior to COVID were not virtual. They were in a room until it ended. It could be very comfortable. It could be very uncomfortable. It just kind of depended. And, then COVID came and mediations were virtual. So then people were in their house and you could, go get a snack or take a nap and,
Right.
go for a walk. And, it just kind of changes the dynamic because, not to say that people are making bad decisions, but when you put them in a room that is not at their house, that they've likely never been to for a significant amount of time, because mediations can take 12 hours. I mean, I've been in mediations at 2 a.m. I mean, for a certain amount of time, people have to focus, right? They have to think about why they're there. They don't, there's not as many distractions, right? And it's not as comfortable. So it changes the dynamic of the mediation when you change it to putting somebody in the comfort of their own home in front of a computer versus being in a physical setting. And, the McCammon Group, which is the popular mediation group, they say that their statistics are just as high with um, online or virtual mediation, which may be true, but I think that the mediations have to change a little bit. I think that you have to prepare. It's a different environment, and I think there are pros and cons depending on who the client is or who the other side is about whether it should be in person or not. But there are mediations that occur, at the court. Sometimes the federal court, for example, I was in one a few weeks ago, and we were sitting in a jury room for hours, and it was a very uncomfortable jury room. It was not very nice. I can imagine that a lot of jury trials settle very quickly because the accommodations were pretty bad. I mean, it had a bathroom like just basically in the jury room. It was like a very thin wall. It was very uncomfortable. So there's that. I mean, you can be in this environment that is not ideal. You can be in another party's, sometimes it's an attorney's office. So it'll be at your office, which is like the home field advantage, or another attorney's office that you've likely never been to. And they can have the home field advantage and they can exert that. I mean, I've had situations where, they were sitting in a conference room and we're eating off like china, and we were sitting in a reception area that had a couch and a coffee table. And, we had to draft a settlement agreement while sitting on a couch at a coffee table, which was like the most, uncomfortable setting to be doing. We had an expert and, there were multiple parties and we were in a very small room that didn't have enough seating or air circulation. I mean, it was just, the venue can be a huge determining factor. So to the extent that we can have it at our office, a place that our client has been to that is familiar, we certainly opt for that. If not, we want to understand where we will be if we're going to another venue. So if there's a way to scope that out before the day of the mediation, we certainly want to do that. If we're going to the courthouse, it's more level playing field because neither party are in the home field. So that is what it is. But we certainly want to know and weigh those options. And if we have a way to determine what that is, we certainly want it to be where we're most comfortable.
Yeah, I think that's right. Yeah, if you're gonna quit smoking or stop drinking coffee, wait until after the mediation is done. You don't want to walk into the room with frayed nerves. You're absolutely right. I remember I had a mediation just years ago at the Equal Employment Opportunity Commission, and it was a long mediation, and they didn't even have like a vending machine. Like there was like nothing. And ever since then, I've been like to my clients, like if we're going to the EEOC or someplace, like if bring some Snickers, bring your cigarettes, bring whatever it is that you need to make it through today, a couple of protein bars, because it's possible. I mean, I was shocked. We were at the EEOC for hours and hours, and luckily we got the case settled. But like everybody's getting hungry, and I was like, "Do you guys have a vending machine?" Like, "Oh, not on this floor." Okay.
Yeah, I drink food now because of that. I want to be
Yeah.
prepared for that too. Because, your blood sugar drops and,
Abs-
people fall apart. I don't want that to happen. So
yeah.
I pack protein bars for that reason. Because
Yeah.
sometimes people are like, we're not going to order dinner because we're very close or we're very far and nothing's going to happen. And that hour keeps getting pushed back. And now it's 10 o'clock, everything's closed. There's no way to leave. I mean, I've been in those situations. So, I want to have water.
Yeah.
Protein bars just in case, one of those scenarios.
Yeah. It can be a very physical, I mean, obviously not touching, but it's a very demanding on your body in some certain ways, because you can be in a room for a long time. Maybe it's an uncomfortable room, and you got to just be, you got to have the endurance, because there's nothing. I mean, you've seen it's nothing worse than having a productive session and then everything kind of falls apart because everybody's hangry and it's 9:30 at night, and things just completely go off the rails, and that's that's a hard way to have a mediation go down.
Yeah.
Talk to us a little bit about when to do mediation. Obviously, I know sometimes it's not a choice if it's court ordered, but in your ideal situation, when is the best time to mediate a case, or is there one?
Mediation can be productive at any stage, even before a lawsuit is filed or after a file. I've had mediation before we filed suit. I've had mediations after we've lost a trial and we're about to appeal it and settle the case at that point. So just about every instance under the sun during a case, we have done a mediation. My ideal scenario is when there's like cross motions for summary judgment, or there's a turning point where it hasn't occurred yet, and you could either win or lose, and both sides have a lot at stake. I think that is ideal because everybody is invested in reaching a resolution at that moment. And I think something about the motions being filed and pending just adds another dynamic to it that makes it more effective, especially in more complex cases. I have seen a lot of cases settle at that juncture, and that has been a really good time, in my opinion, for difficult cases to settle because after you've written all the briefs, all the issues, the discovery is done. It's sometimes more difficult at the beginning because you don't have all the facts. You don't exactly know what the numbers are, but by summary judgment, the discovery is done. So at this point, I think that you can paint a very vivid picture of what this would look like going forward, and you know exactly what the risk factors are. And I think that very good decisions with respect to settlement can be made at that juncture. But I tell people, you can save a lot of money by mediating early. So if it is a case where discovery would kind of be more cost prohibitive than anything else, I think that doing it early can be very helpful. Doing it before a lawsuit is filed, I think is ideal if the facts lean that way. I mean, if we can send a copy of the lawsuit and say we're going to sue you, but I think we should go to mediation and broker a deal before we've even sued the other party, I think that's extremely ideal. And we've had that go, been very successful in doing that many times. So, it just kind of depends.
Yeah, I think it's particularly when you got something that's going to be potentially publicly explosive, right? And there's before things are like a really serious sexual harassment case, where the other side is already motivated to kind of read some resolution, I think you're absolutely right. Like you can, you know, it can be very productive for both sides to do one before you've even filed a lawsuit. And yeah, you're right. Like particularly after summary judgment, I remember I had a case years ago where we were before a judge that was known to be very defendant friendly, particularly for employers. And our case, I felt, was so strong. We actually filed for summary judgment as the plaintiff, which, as you know, is somewhat rare. And while those motions were pending, so cross motions for summary judgment, we had mediation, and we were able to successfully settle it because, the insurance adjuster was there. As you know, sometimes getting the insurance adjuster to attend can be a pain, but the insurance adjuster was there, and we were able to say, like, it was very interesting to me because even the magistrate judge who we were mediating before said, basically, you guys are going to lose at summary judgment, but the record, I think these were his words, like that the record is littered with opinions overturning this particular judge. And we were able to say to the other side, like, look, even if we lose for summary judgment, we're going to appeal this case, and you guys are going to have to spend more on attorney's fees. And so even though, and it was clear because we'd already had oral argument before we went for mediation, and it was clear we were going to lose. Like the judge made some comments that was just like, dude, are you kidding me? But anyway, it was clear we were going to lose. So the defense came in there very smug when the magistrate judge was like, oh, well, how did oral arguments go? I was trying to equivocate, and the defense was like, yeah, we got the back. But anyway, your point is well taken. Because we were able to show, like, okay, you guys are probably going to lose at this stage, like, but our case is really strong. And if we can get before a good panel at the Fourth Circuit, this is going to get that more expensive for you. And we were able to get a good settlement. And I think that would not have happened had we not had that much briefing done on it.
Yeah, I mean, that's similar to the case I had that went to trial. And we lost a trial and filed a notice of appeal and then went to mediation. And there were a number of things that were very concerning that happened in the trial that I think the other side knew as well, even though they won. And the mediator, hammered those things like, this is problematic. So nobody, who wants to go up on appeal and possibly get this remanded? I mean, this is an opportunity right now to resolve all of these issues before people, everybody was tired. We had spent, the case has been on for years. We've now went to trial, and now we're considering appeal. At that point, the parties want this to be over, and this is an opportunity. There's still leverage at that point, and we were able to utilize that leverage even after the trial that didn't go our way because the appeal would have turned out pretty interesting, I think, had we had to go that direction.
Yeah, no, I think that's absolutely right. So talk to me a little bit about, any work you might be doing with opposing counsel. What are you doing, if anything, before mediation with opposing counsel?
So I tend to have pretty good relationships with opposing counsel, even though we're adversaries. And when you're mediating a case early on, there is usually this issue about neither side knows all the facts. So if there is an opportunity to amicably exchange some very important information that is going to be at play at mediation, and just do that, voluntarily, perhaps without formal discovery and without motions to compel, if there's some damage information that can be exchanged or, those are the conversations that we usually have with opposing counsel. And a lot of people are usually amenable to that, because you don't want to get to mediation and, one, either not have the people there that need to be there to reach a resolution, and two, not have the information that you need to formulate what the damages are or what, a party can settle for. Those are two, it doesn't need to be down to the dollar amount, but you need to be an idea of, like, a range of possibility. And sometimes a party does not have the information to come to that number. So if there is some kind of impediment like that before going to mediation, and we can resolve that by just sending over some documents that they would get in discovery anyway,
Sure.
It just makes sense to kind of, let's just get past that. And the second point, what I made about not having all the people in the room, that is a big one. I've been to too many mediations where, they say that the decision maker is there and the decision maker is not there, and that is very problematic. And I think that mediators are just as equally frustrated with that, and they make a very big deal about that now. If there's an insurance adjuster, if there is a person who you need to call to be able to write this check, then they need to be there hearing what the arguments are, because they're not
Right.
going to write that check without understanding the context of what's going on. So why are you here and they're not? All the people who are involved in this decision need to be there. And we push very hard to identify who those people are and make sure that they are available and there during the mediation for it to be effective.
Yeah. Yeah. I think that's key. Particularly having all the right parties in the room. I think this happens probably pretty unique to the EEOC in employment cases, but mediation is generally optional there. But sometimes defendants will want to mediate because it's free discovery for them, right? They want to see what's happening. But I've learned the hard way over the years, like to call opposing counsel beforehand, be like, is this real? Like, you're just like you said, like, are you gonna be there? Because I've had them send people from HR, which fine, like HR people are great, but like they can't write a check. They're just there for what? I don't like, we're all wasting our time because you sent somebody from HR who has no authority to settle the case. Or like you say, sometimes like, the attorney will be there, but the person who's going to actually, sign the check, whether it's a board member or, like you said, insurance adjuster, that's also really frustrating to get there and have the attorney be like, oh, I'd love to settle this case, but, I don't have the authority. And it's like, why are you wasting our time? So I find it, really helpful to talk to opposing counsel beforehand and be like, okay, like, let's not waste your time and mine and our clients. Let's, are we even in this? Are we even in the ballpark? Because if it's a optional mediation, particularly at the EOC, and they're not willing to put anything on the table, then, like you said, and let's wait till later in the litigation where there's been, more activity and parties might be more interested in actually trying to reach some kind of resolution.
I think it's important to determine that. And, it's usually pretty clear whether if the opposing side is not going to participate at all and they just feel like you have a terrible case and they're not, it's usually pretty clear, and they're usually not that inclined to go to mediation if they feel that way. But in a lot of the cases that we have, even if they feel like they have a great case, they're not, there's other factors at play. Like, this is going to cost your client a lot of money. This is going to go on for a very long time. This is going to create emotional energy. Your emotional energy is going to be going to this instead of something else. So even if we can't sell them on, whatever the equities of the case are, there are some other issues at play that they need to consider if we're going to, go forward with litigation. And usually that is enough to get some good faith discussions moving in mediation.
Yeah, absolutely. Well, Margeaux, we're coming up to the end of our time here. Any final pearls of wisdom you want to share with our listeners about mediation, or if we covered everything?
I would just say, I think it's something to keep an open mind to and to explore if that is an opportunity. I don't think it's ever too early to start that discussion. I strongly believe in mediation, and I think that it, is a very favorable, procedural mechanism that allows a lot of parties to reach a resolution and buy into the result. So if there's an opportunity to do mediation, I, strongly encourage people to think about it and try it. And, it doesn't work 100% of the time, but usually gain something in the process of just going through it. Even if it doesn't settle, it may settle later on because of something that happened in mediation. So I would just say keep an open mind, and if there's anything that our firm can help with respect to business mediations or business disputes, we certainly reach out. We're here to help you with that.
That's great. Well, I highly recommend that. Margeaux is one of the best. So if you got one of those cases and you're looking for a great attorney to get it done, Margeaux is, you'd be hard to beat her. So we'll put your website in the show notes. And I think I finally got it right at the beginning. I don't know why I wrote Thompson. I must not have had my first cup of coffee quite hit the bloodstream yet. But it's thomaslawplc.com. I got that right. Any other ways people should reach out to you or should consider?
Yes, the phone number is 703-957-2577. My email is mthomas@thomaslawplc.com. And we are very active on LinkedIn, so come check us out there, and you can read a little bit more about what we do and the attorneys, and hopefully we can help out if you have any business dispute issues.
Great. And we will put all that information in the show notes. And thanks again, Mario. This has been fantastic. I'll let you get back to the next thing on your desk.
Thank you. Thank you for
Take
having me.
care.